Good morning, everyone. Welcome to the webinar. We will let the attendees roll in and we'll get started shortly. Good morning, everyone. The webinar will start shortly. We're almost done letting the attendees in. Okay, it looks like the participants have populated, so we can get started. So good morning, everyone. This is a webinar that's being put on by the LA County Bar Association's Labor and Employment Law section, and we are the Breakfast Program Committee. So we usually meet in person, but we've taken these virtually, and I will turn it over in a moment. This is our Discovery and Arbitration, What You Need to Know Now panel, and I am Ramit Mizrahi, Breakfast Program Committee Head. Let me know if you have any questions, but I will turn it over to our wonderful panelists to introduce themselves.
Good morning, everyone. This is Joel Grossman. I'm one of the arbitrators and mediators at JAMS. I want to thank Ramit Mizrahi, who always has organized beautiful seminars for us at the LA County Bar Labor and Employment section. Thank you, Ramit, for all your work. I know that those of you who normally come to JAMS in our annual seminar are going to miss having breakfast at JAMS, but on the other hand, you can attend this webinar in your pajamas. So there's always some benefit there. You are not going to be seen, only the speakers are going to be seen. We're going to discuss today discovery in arbitration. And I know that a lot of people have issues in what happens in arbitration. What are the discovery rules? Do they vary from provider to provider, from AAA to JAMS? And what about this new rule about prohibiting discovery from third parties? All of this is going to be discussed at length by our speaker, Barbara Reeves. I'm going to call on now my co-moderator, Debbie Saxe, who will introduce Barbara.
Good morning, everyone. I'm Deborah Saxe. I'm an arbitrator and mediator at JAMS, doing mostly employment law. It's my pleasure now to introduce Barbara Reeves, who's also a mediator and arbitrator at JAMS, who does a fair amount of employment law, a lot of it actually. Barbara's been a mediator and an arbitrator, full-time neutral for many years, and is an expert in this area of discovery. So with that, I'm going to turn it over to Barbara.
Thank you, everyone, and it's a pleasure to be here. I will start off by speaking, and then what I'm hoping and what Joel and Deborah are hoping is that you will ask questions. There's the Q&A box at the bottom, and they're going to be monitoring that as they see questions coming in. They're going to be asking me questions, and we'd like this to be interactive. Obviously, it's difficult with so many people, but if you ask questions, that's what we want to know, is what are your questions about this area? And I'll start by highlighting some of the things that are in the outline that is with the materials that were handed out. As you all know, we start with, in arbitration, there's sort of four pillars. There's what does Armendariz say, for example, the case that says you must have adequate discovery? What do the recent cases say about third-party discovery? Because adequate discovery is fine, but what about third-party discovery? Then, of course, there's your arbitration clause. That is like the directions that you get with your handbook. You know, we buy something, there's an instruction book. This is, you've got an arbitration, look at your arbitration clause. And then there are the rules of the organization that you're with. So I'll start by running down some of these examples with practical tips, and then I'll hopefully get questions and give examples. One thing that I do want to say, and this goes for Deborah and Joel as well, is that we're giving general advice, we're giving examples, but Your case is always different. Every fact case is fact specific, as we'll be discussing. And none of us expect to have this thrown back at us in arbitration when you say, but that's not what you said last week, because of course it changes depending on case to case. So let me start with the arbitration clause, because that's the first thing you get. When you've got an arbitration, you look at it and say, you know, that's where it tells you where to go, which arbitration organization, and all of that information. But what does it say about discovery? Quite often, it says nothing about discovery. Sometimes it puts limitations. As you know, if you read some of the cases, there are arbitration clauses that say you get 2 depositions and no written discovery. There are arbitration clauses that say apply the California Code of Civil Procedure or the Federal Rules of Civil Procedure. They can be any level of formal or formality or informality. And so that's the first thing you look at, is what kind of limitations do I have under my arbitration clause? Does it specify applicable discovery rules? Does it specify limitations? What does it say about third-party discovery? And the reason that's important is that's where you start. You may be able to show that the arbitration clause should be expanded, or that it's not valid, or that the limitations are not valid, but start with the clause. So that's the first thing that I'll mention. And as you know, and we'll be talking about some of the cases, when you see cases, you'll see that the ones that get to the court are the ones where somebody overreached in their arbitration clause and tried to make it too narrow, tried to restrict it too much. And that's where the clause gets in trouble. Now, one thing to consider, so you've got this arbitration clause. It's not written in stone. You can talk to the other counsel and ask if suggest some changes. Quite often cases come to me and the arbitration clause says one thing, and then the parties show me a post-dispute resolution agreement. So an agreement they just entered into last week or a few months ago, which says, these are the rules we're going to apply, notwithstanding what the arbitration clause says. So as you know, you're all litigators. These arbitration clauses were sometimes thrown together by a knowledgeable employment lawyer or a knowledgeable litigator, but sometimes they were just put in there by somebody who said, quick, I need an arbitration clause. And it may not really apply to your situation when you get to it. You're looking at it and saying, well, that's not at all what I want. Now, obviously, counsel don't always get along, but if you can, at the very beginning, talk to your counterpart and ask, for instance, it says two depositions. Can we agree that the arbitrator can order more for good cause? Or it says all discovery, I've had this one, will be complete within 60 days of initiating the arbitration. And you say to the other side, that's not going to work. Or you ask, are you willing to amend it to allow third-party discovery or not? And you talk about that. And an amendment, I believe, is valid. Now, I have had a case where that was challenged, where the third party who received a discovery subpoena said, I'm looking at the arbitration clause. That's what gives the arbitrator authority. And that original clause says nothing about third-party discovery. And the party said, well, we entered into an agreement that allows for third-party discovery. And the third party said, I'm going to take that to court. I don't think you have that authority. So the issue, as we'll discuss when we get to the case governing third-party discovery, it's a recent case in California. So the law is still developing. All right, so that's the takeaway on arbitration clauses. You can amend them, you can adjust them if you look at it, if you can get along with the other side and you recognize that in order to make this proceed well, it would be to everyone's advantage to, amend it. An oral amendment is fine too, but it really does help that you put it in writing so you've got it, or confirm it in an email. Then the next question is, well, what are the rules that apply? Where do we go to arbitrate this? And by the way, something can say that the AAA rules apply, but if it doesn't say you have to use the AAA, the American Arbitration Association, you can pick any one you want. Likewise, if it says the JAMS rule apply, there's usually a default expectation that whatever rules apply indicate what the parties expected or which provider they expected to use, but it's not necessarily the case unless it calls out that provider. Now, likewise, or the flip side is if your clause says JAMS shall administer the arbitration or the American Arbitration Association shall administer it, then again, by default, it's expected that that organization's rules will apply unless that's spelled out. Now, turning to the arbitration organizations, the rules on discovery on their face are very, very different. As applied, they may not be so different. So let's start with the American Arbitration Association.
These are also in your handout.
Yes, these are this rule and the JAMS Rule 17 are in your handout. The AAA has a Rule 9 for discovery in the employment arbitration rules, which is one sentence long. And it says the arbitrator shall have the authority to order such discovery by way of deposition, interrogatory, document production, or otherwise, as the arbitrator considers necessary to a full and fair exploration of the issues in dispute, consistent with the expedited nature of arbitration. I call that sort of the functional equivalent in our employment world of constitutional due process. You know, if you remember when you studied constitutional law and you learned about due process and you said, what the heck is due process? You know, it's such process as is due. And you learned that it's a pretty flexible concept. Well, it's the same thing with that rule. All right, sufficient discovery as necessary to a full and fair exploration of the issues in dispute, subject to how the arbitrator feels that day. So that's something to be careful of. And I'll talk about how do you get what you want out of that rule, depending on which side you're on. Now, let's look at the JAMS rule. The JAMS rule is much longer. And we tried to spell out the procedures. I mean, if you note, if you go to the CCP, you know, there's pages, I don't know, 50 pages or something worth of procedural rules, many of which apply to discovery. So we start off with the most important rule, which is Rule 17A. This rule is a little bit interesting because it starts off by saying the parties shall cooperate in good faith in the voluntary and informal exchange of all non-privileged documents and other information relevant to the dispute. So on the one hand, if in fact you comply with this rule, there shouldn't need to be any other document discovery or information exchange. It says that you have exchanged all relevant non-privileged documents. I mean, what else are you going to ask for if you've gotten all relevant documents? You can't ask for all irrelevant documents. On the other hand, it starts off by saying it's good faith and voluntary. Well, what does that mean? I think you'd say most arbitrators, when you read through the rest of this rule, say that this is something that the parties must do. Rule 17, they must make a Rule 17 exchange. Now, what if you don't want to make a 17A exchange? What if you really like the good old rules of civil procedure, the CCP, and you say, I would just rather follow those rules. I don't want to have to search through everything and decide what's relevant. I want to wait for the other side to ask me what they want. Well, again, you lawyers can agree with each other that we're going, in lieu of Rule 17, we will have document production requests. So again, this is your arbitration. You can structure the rules. Before you jump in too far into that, though, I would remind you that the people who drafted these rules, either at the AAA or at JAMS, thought about this a lot. We've all had a lot of experience and we know how these work. And we kind of think these work better than just incorporating the entire procedures that you would have in court. Now, Joel raised with me the other day an interesting question. What if, and that is, does Rule 17A give you the basis for a motion to compel. Can you say, all right, I've been waiting. That defendant hasn't given me, or respondent hasn't given me very much yet. I know they haven't given me, quote, all non-privileged information relevant to the dispute. I'm bringing a motion to compel without having to go through the steps of issuing a document production request. I think you probably can, but you might want to, in order to make the work not so difficult for the arbitrator, specify what it is you think hasn't been produced, so it's not just a black box. Now, a couple other things to remember about Rule 17, and then I'll pause for a minute, Joel and Deborah, to see if you have any questions or if there's any that you want to ask me, which is, it's under Rule 17C, it is ongoing. I'm sorry, yes, 17C, it's ongoing. So if at a later time, for instance, you're working remotely now, within the next 2 months, you actually get to go to the office. You get to go to your client's office. And lo and behold, in a filing cabinet are documents. You remember documents. Before we had ESI, we actually had paper. Well, you find some documents that you didn't know were there. There's an employment file, part of which is on paper that wasn't electronic. Who knew? You have to produce that. It's ongoing. The other side doesn't have to keep asking you for documents. And then you say, all right, well, what about sanctions? So what? What if I don't provide things I should provide? And Rule 17B says that, I believe it's 17B, you may use that if you don't comply, the arbitrator may consider such sanctions, you can't, and one of the rules is it says you cannot, and Rule 17C, I'm sorry, that you may not use the documents that were not exchanged at the hearing. Well, if you can't use documents at the hearing, okay, that may be bad for me if I wanted to use the documents, but what if I know there's bad documents on the other side and they don't want to use them at the hearing, and I know they've got to be there? If you can put together a case, as much evidence as you have, you can move for sanctions under JAMS Rule 29, which provides for appropriate sanctions for the failure of a party to comply with its obligation under any of these rules. And those sanctions are just like the ones you know from court, the ones you know and love. You can ask for an assessment of fees, arbitrator fees, for costs and fees that you've incurred. You can ask for exclusion of evidence, or if it's something that you don't want excluded, you wish you had it and you know it's got to be there, adverse inference. Or in extreme cases, you may ask the arbitrator to determine an issue adversely to the party that failed to comply. In a recent case, the parties built up so much evidence, or one party did, the claimant, that the other side had documents. They found copies in third parties' possession that had not been produced by the respondent. And finally, the claimant applied for terminating sanctions. That's a pretty stiff sanction, and it does cause an arbitrator to kind of, stiffen up for a minute and wonder, all right, am I really gonna do this? And in the case that I had, I wrote an award finding terminating sanctions that I included the phrase, enough is enough. And so that when you get to the point that enough is enough, you may ask for sanctions. On the other hand, don't go running in for sanctions all the time. You'll sound like, the boy who cried wolf.
Barbara, let me jump in with a question. And I want to say to the audience, we only have an hour, so we're not going to get to all of the questions, but thank you and keep them coming. But let me give you this question, Barbara. If an arbitration provision provides that the arbitrator may, in his or her discretion, permit more than a certain number of depositions in an employment case, what factors do you consider to be the most important in determining whether to permit additional depositions?
All right, and for this, I'm going to turn and look at Armendariz, the sort of gold standard of discovery in employment. And as you know, it starts with the words, pull this up. It starts with the words, or the key words are adequate discovery. You know, what is adequate discovery? And then what I say to the parties is make a factual case. For example, what is the factual support that says you need more than 1 or 2 depositions? Specifically, in a recent case, which is cited in the materials, Davis versus Kozak, here we get a good example, a good sample of what the courts look at. You need to make a simple showing of need. Okay, what's that? Well, Mr. Davis, had showed that he had worked there for 15 years at the company. He had a list of people whom he said would confirm that the company's policies were discriminatory against age and that it permitted a youth culture that involved sexual harassment. He was old. He was an older man, so he wasn't getting sexually harassed. So they list, and he says, and so I need the depositions of these individuals who can verify this. And then he came and he said, I need documents and testimony regarding my work performance. I need people who can testify about what the policies are here for discipline. So if you come in and give factual examples, the court in Davis versus Kozak dealt with an arbitration clause that allowed for 2 depositions. And the court said, that's just not going to work when you've got a 15-year employee who has demonstrated that he has more people that he wants to depose. In a case in which I ordered 8 depositions on one side over the objections of the other side, the claimant demonstrated the names of the people that she wanted deposed and why. I said, do a chart for me. For each individual, indicate who they are, what they know or what you believe they know, and why it's relevant here. And after that request, I granted it. In another case, they came in with a list of 23 depositions. And I said, that's too many. And I said, but if you want to really show me why you need 23, you can. And by the time the party sat down, they narrowed it down to 10. And 10 is what we went with, because they were able to show what specific information is necessary on the claimant's behalf for the claimant to vindicate his or her statutory rights under FEHA, for example, or on the respondent's side to mount an adequate defense. This sometimes gets into obviously sensitive areas such as medical records and depositions of medical professionals if somebody is claiming emotional distress or physical injury as a result of stress or discrimination. And so it can be embarrassing, it can be sensitive, but if you show a need, that's what you'll find when you read through the cases. And if you look at the Davis versus Kozak case, again, which I've cited, the author of that opinion did a great job of listing prior cases, lots of good citations there. You can find something for whatever you want. I'm going to, although another case that was interesting was where the claimant asked for too much and asked for documents and interrogatories and depositions that just were huge. And the arbitrator said, be careful. I may order this. No, this got to court. This went from arbitration into court then. And then, I may order, or I may agree that this can be ordered, but I may shift fees. And if you require the other side to do so much discovery, especially if it's electronic discovery, e-discovery, and they spend $100,000 doing it, or $200,000, and then you come up with 5% of what you get is useful. The rest is exactly what the other side said, which is totally irrelevant. The arbitrator may say, fine, I'm shifting fees, and there you are, and you have to pay the fees or the costs. So a tip is Avoid being over aggressive and drop the phrase any and all documents that refer, relate, or pertain to issue. Because that's not appropriate in arbitration. You don't need any and all documents that refer or relate or pertain. See how specific you can get. Now, in order to save time for questions, I'm going to skip into third-party discovery and then a little bit into pandemic discovery. Third-party discovery, the two cases are cited, and that's Extron, AIXTRON, which is our own California Court of Appeal from last summer. You remember the great summer of 2020. And then CVS Health versus Vividus, which was from 2017, I think, the Ninth Circuit. We know, having been practicing for years, since the Ninth Circuit issued the case in CVS versus Vividus, that in the Ninth Circuit, one may not get third-party discovery under the Federal Arbitration Act. So for the last 3 years, what have people been doing? They've been incorporating the California Arbitration Act into arbitration clauses or into their employment arbitrations so that they can try to get discovery. How could you get third-party discovery? And by third party, I mean serving third-party subpoenas on witnesses, serving deposition notices or deposition subpoenas on third parties. And so under the CCP, you are permitted to get third-party discovery in cases for wrongful death or alleging personal injury. Employment law, plaintiff's lawyers, claimant lawyers are smart enough to figure out that we're going to claim that my client who was stressed, couldn't sleep, all these things because of discrimination, suffered personal injury. And many arbitrators have allowed discovery, therefore, under 1285.03, because emotional distress is, they would say, all right, I agree that that's personal injury. Alternatively, you can simply agree to incorporate 1285.03. The statute says if you agree to incorporate it and expressly call it out as being part of the discovery that's permitted in your arbitration, you can do that. People were just, proceeding under the California code. Under the California Arbitration Act. Then along came Extron, and Extron said in a very, very lengthy opinion, I forget if it's 50 pages or 40 or something, it's long, said, we're going to revisit all this, and we're not even sure if we're under the California Arbitration Act or the Federal Arbitration Act, but it doesn't matter because we hold that a simple arbitration clause that does not expressly say you may have third-party discovery does not give the arbitrator power to order third-party discovery. And you can understand that. After all, who am I, a private arbitrator, to be able to compel third parties to come into depositions when they never signed that arbitration clause? What do they, what am I being involved for? But there's a statute. We understand under the California Arbitration Act and the Federal Arbitration Act, we do treat arbitration with a dignity which allows subpoenas to be issued. Now, the parties can stipulate then, after a dispute arises, that they will apply CCP 1283.05. And that I raise it in every preliminary conference. Quite often the lawyers haven't heard of Extron, and so they're in a position of saying, I don't know, got to get back to you on that. And so I explain that I can't order third-party discovery unless you both agree to it. And sometimes the lawyers both agree. Sometimes one wants it and the other one doesn't want it. And so then you say, well, what's the practical result of that if they won't agree? We have what we have sort of called a workaround, but I don't really like that phrase because it makes it sound like you're getting around something. And that is if two instances. One is, what if one party wants third-party discovery, the other one doesn't? Well, then the arbitrator can't authorize it. Or what if both parties want third-party discovery, but the third party insists that it's not permissible, and case law hasn't developed fully there? The arbitrator has to look and say, well, what are we going to do? Is it going to prejudice the parties to delay production of the documents until the first day of the arbitration hearing, because an arbitrator may issue arbitration subpoenas to third parties to show up in person or to bring documents to the arbitration hearing. But who wants to start an arbitration hearing and have witnesses that you don't have any idea what they're going to say, and they're going to show up, and you're going to make the arbitrator sit there through what looks like what sounds like a deposition of this witness, or they show up and they dump a whole bunch of documents on your desk or a thumb drive and say, here's all the documents, what are you going to do with it then? So we have the ability to convene an arbitration hearing in advance, whether you call it I call it an arbitration hearing, and I'll say, all right, the subpoena calls for documents to be returned on X date. We will start an arbitration hearing on that date for the sole purpose of getting this evidence in. Now that means the arbitrator has to show up, and and if the parties don't have to show up, the arbitrator has to show up. Now, under our current situation, some cases have come up where the question is, all right, so this witness is in North Dakota and I'm the arbitrator and I'm in Los Angeles, as are the parties. Does that mean I have to fly to North Dakota in order to get production of these documents because I have subpoena power, but I can't subpoena the witness to come down to Los Angeles? Well, some people say, fine, let's do it on Zoom. There's courts still struggling with the answer to the question, if it requires a hearing before the arbitrator, must the arbitrator physically be there? Or am I sufficiently physically here because I'm on Zoom? That raises another question, which is, what about the arbitration clause that says this arbitration will take place in San Francisco? And there's a party in San Francisco, there's a party in Los Angeles, I'm in Los Angeles. Must I physically go to San Francisco, or during the pandemic, and even afterwards, can we do it on Zoom and deem that it's taking place in San Francisco? I've held the latter, and I've said to parties who have pushed and tried to have an in-person hearing in the middle of this pandemic and said, no, I think we can do it on Zoom. And I know you want it in person. Sometimes I was aided by the fact that the governor shut everybody down again just in time. And so we couldn't do it in person. Other times, another occasion, I said, fine, we'll do it in person. I'll be there, but you must have masks, plastic barriers, take temperatures of everybody as we show up. And I'm not ordering anyone to come. So if the other side's lawyer or party or witness doesn't want to come in person, I, the arbitrator, don't want to be the person to require someone to show up in person, and then they get COVID-19, and that's not what I intended. Now, another dispute that came up recently is what happens if you do order this, and I say, all right, we'll start a hearing, you come and you produce all the documents. Are all those documents suddenly in the record? Have they all just been admitted as if they were actually produced in the middle of the or used in the middle of the arbitration hearing? I don't know the answer to that. Obviously, nobody wants all, tens of thousands of pages to be in the record, because there's maybe a lot of stuff that's irrelevant. But that's an issue we don't know. And then finally, another issue that came up recently was a deposition. If you want to do depositions, and one party says, the respondent, for instance, says, my client, the CEO, wants me there in the room with him during the deposition. And I will socially distance, I'll wear a mask, but I have to be there. And the claimant's counsel says, well, if you're going to be there, then I want to be there because I want to make sure you're not coaching the witness. And I'm allowed to be there just like I am in any in-person deposition. We're all there, we can all see each other. And if I'm going to come, we're going to have to, again, socially distance, wear masks, get tested, get cleaned, everything. And so in the middle of this pandemic, I'm always working on ways to accomplish the discovery, but without having to, people have to be there physically. And someone says, what are you going to say to the court if this goes to court? What's your explanation? Last year, my explanation was, it's 2020. That's where we are now. I guess this year, my explanation is it's 2021. And everybody's not vaccinated yet. So it's a matter of being practical.
Barbara, here's a question from one of our audience members. Do you have the power as the arbitrator to order a QME, a qualified medical exam, because the claimant comes in with claims of emotional distress? And to add to the complication, can you order a qualified medical exam of the claimant here during the pandemic?
Good question. What do you think, Joel?
Well, it's certainly something that in court is always recognized as something that is available.
Right.
And most plaintiffs' counsel that I have dealt with don't really object. They understand that that's part of the ball game. I also think it's a relevant question under the Aikstron case with third-party discovery. Can the respondent subpoena records of the claimant's psychiatrist? Would they be relevant to, again, the emotional distress claim? So these are things that are coming up in almost every arbitration.
They are, and when you consider that as a practical matter at present, people go to the doctors. I mean, we do, most doctors require an annual physical that you have to show up in person for. I mean, after all, it's sort of hard to take your blood pressure and everything over the phone or on video. And doctors' offices are, careful. Everybody's got the protective gear on. And so I would think that a third-party medical exam, a qualified medical exam, could occur in a safe condition. But yes, it's something you've got to approach gingerly. Another issue that comes up, and I see there's a question relating to trade secrets. I'm also having it in connection with medical records. What if you do manage to, what if there's something that really is, and it's the same for any kind of privilege, medical records that the claimant says, there's some stuff in there that's relevant about the stress I experienced and the sleeplessness and what I reported to the doctors and the medication I was put on, but there's other stuff in there that's not relevant, such as my sexual history or something. What do you do? And it's the same as if somebody says, well, we've got a trade secret, but we need to determine if it's really a trade secret, but if we tell them what it is, then it's not secret anymore. Can you bring in the arbitrator to look at, and have an in-camera inspection? And I'll tell you that when my case manager first joined JAMS and he heard that one of us was having an in-camera inspection, he thought it meant that we were being video. But I said, no, that's not it. But can you do an in-camera inspection? And the same thing applies to privileged documents. So you try to get the parties to agree, because it's hard usually I get the parties to agree that the arbitrator may look at the confidential information, allegedly confidential, and determine what should be produced. If a party objects to it, some courts have held that an arbitrator and a judge, or a judge or a magistrate may not look at privileged information. So that's another issue. And of course, there's always the question that comes up when it's a motion in limine, and I say to the parties, tell me again what it is you don't want me to know. When they say we object to having this evidence, the following evidence. So those are great questions, and they're very difficult. Debbie, Joel, do you see any other questions there? We've still got 20 minutes.
Yeah, there's a bunch. One of them is specifically about Rule 17. Do you have to identify the documents such as you might do in court with a request for production of documents, or can you just send over a giant box of documents without saying this applies to this or this applies to that?
The rule doesn't specify that you have to identify them, but you may get an arbitrator who's like me, who says you got to identify them, because with, it's one thing if it's a box of documents, it's another thing if it is, as in a case that I have, a terabyte, I don't even know how big that is, of data that was produced by Google. Google is a third party. But good. That happens when you say, "Oh, I lost my email account, my Gmail account," and the other side says, "Well, it's relevant, so we're going to go get it from a third party, namely the host, and they dump all this data." And I say, "No, that doesn't work. Somebody has to review it and identify what it's applicable to." Again, in another case where 20,000 pages were produced and nothing was identified as being responsive to the RFPs, I said, unless you categorize those, even if it's sort of general, as to which category where they belong to, that's not helpful. Now, the rule doesn't allow that. What I want to point out something else is the AAA's rule, Rule 9, expressly does call out that you may have interrogatories and document production requests and depositions. The JAMS rule, Rule 17B, provides for one deposition as a matter of right and additional depositions upon a showing of reasonable need. And that's the point I addressed earlier: reasonable need for the requested information, the availability of other discovery, and the burdensomeness on the opposing party and the witness. So I also allow interrogatories, and I caution it. I in my case management, my preliminary order after the preliminary hearing, I say interrogatories may be asked if they are a simple question and if it is designed to get information in a more straightforward and efficient fashion than document production requests. For example, rather than saying produce all the documents that identify every supervisor this employee had during her 15 years of employment, I'll say ask that in interrogatory. Please provide the names of all supervisors, period. The other thing that I ask is, and this was also criticized in one of the decisions, if not the Davis versus Kozak, one of the cases that was cited, is to I'm trying to remember which case it was. If you're going to, don't make it look like court. Don't make it with 10 pages of identification of what the word "you" and "document" means, and then 15 pages of instructions. It's like we're not in court. Just simple document production. I mean, you can ask after you've gotten, and then so then there's the question of, if you're going to do document RFPs, do you do them before or after Rule 17? Well, on the one hand, if there are specific categories of documents that you want, you might put them into an RFP, which can be as simple as an email with a list of production requests. Produce this, this, this. That puts the other side on notice when they're searching for all relevant documents under Rule 17 of what you think the issues are, what you consider relevant. On the other hand, if you wait until you get the Rule 17 production, you may get everything you want, and then you don't have to ask for any further RFPs. I tell the lawyers.
Audience members ask the question: should the parties meet and confer prior to producing the Rule 17 documents, so that each side has some sense of what the other side is going to produce?
Yes, that's very helpful. And I mentioned that, and I also remind them that they should meet and confer about the form of electronic production. You don't want to spend $10,000 or $20,000 producing electronic discovery only to just find out that the other side doesn't have the capability of reading it, because there's different forms, different technologies. And then the arbitrator will require that you produce it either in the form, like we do in court, the native form as maintained, or in a form that is readable and accessible. So confer about that before you spend the money to produce documents.
There's another question here, Barbara, which I think is interesting. It's from Pete Dickinson. Do you expect the parties to have a litigation hold in place?
Yes.
I do too.
I do too, yeah. Joel? Yeah, I mean, it's just like litigation. Once a case gets started, the lawyers need to talk to the parties and explain what's going on and what needs to be preserved. There's a case in a recent ESI case where the party switched to another, another platform for all their documents and basically deleted a whole lot of stuff, just cleaned house. And they claimed it was just in the ordinary course of business. They didn't know they were supposed to preserve anything. What happened was this is called discovery about discovery. Then the other side said, fine, we want to take a deposition of your IT guy or someone who's involved. The IT guy got deposed and just destroyed the case. I mean, he said, well, no, we were deliberately getting rid of stuff so that we wouldn't have everything for discovery in general. In other words, not with this particular case, but our lawyers advised us, in-house lawyers, that the less documents we have, the less discovery we have to produce. And we were looking to get rid of documents that were bad. And the court said, that's a problem. That's called spoliation. So yes, I do expect that documents will get held, retained. And I have a case now where that issue is in front of me. And I found that there was spoliation. And now the question is sanctions. So you don't want to be in that position.
I wanted to add something. Often these employment cases start out in court. There's a complaint filed in court, and then the defendant files a motion to compel arbitration. That's a really good time for the parties to talk about discovery and whatever it is the plaintiff wants. Oftentimes the plaintiff can say to the other side, look, I'll stipulate to your motion to compel arbitration, so long as you agree that CCP applies for discovery. And then, you've got a deal and you go to arbitration and you've got the discovery you want. I see it a lot. There's a complaint, there's the motion to compel, and then there's a stipulation to arbitrate the case and pursuant to CCP for discovery or FRCP for discovery or whatever. It's a good time. It's a time when the plaintiff has some leverage.
And there's another question that I just saw, which is about, pull it up. There's sort of two related questions here about what, I said, get rid of the phrase any and all documents that refer, relate, or pertain. Well, if the courts have also recognized that if you're the plaintiff or the claimant, you're in an unequal position compared to the defendant, the company. The company has the documents. They usually have the documents and the witnesses. If you apply a neutral standard, which says, I'm going to allow you each the same latitude for discovery, that's in a practice not neutral toward the plaintiff's side, the claimant's side, because they need more discovery. They don't have it. They don't know what's there, and they don't have access to the employees of the employer. I mean, the employer says, fine, I don't need to take 8 depositions of all the supervisors. I'm just going to call them up on the phone and we're going to talk. They work for me. So, that's a difference. And I do hear that where the employer says, that's not fair. You've given them 8 depositions and I only want to take 1. And I say, well, that's because before those 8 depositions occur, you're going to talk to each of the people because they're all still employed by you. So that's, and so I give the plaintiffs and the claimants some leeway in terms of asking for documents in a certain category. Just try to get rid of any and all. You might use phrases like documents that evidence something or other. Documents, or you might say, I want emails that refer to name of claimant, and discipline performance, something like this. List some words. The other thing you're going to run into is a lot of keyword searches, and arbitrators don't always like to get involved in the keyword searches because how do I know what the keywords are? I don't know your company, especially when you may have code names for things, not, but like nicknames that, the company calls this project, the Joel Grossman project. They put a name on it. That's Joel's project. That's Deborah's project. and I don't know what they mean. So again, that's a time to say the lawyers should meet and confer and try to identify issues and what keywords they want to have used. Another dispute is, what if you're using keywords? And I say, well, here, I'll look up the keywords rather than respond and give you them by keywords rather than by the 32 document production request categories you gave me. In arbitration, I allow that because that's how keyword searches are. They don't filter it out by document production request. If you have stated you want the CCP to apply, you may have to live and die by the CCP, which says you have to identify things by the document, the specific request. There's one question just asking whether we're finding arbitrations taking longer or shorter during the pandemic, and I invite Joel and Deborah to comment. I'm finding that they're going very forward very efficiently unless and until the lawyers get burned out a little bit or get tired of all this remote stuff and say, look, I just can't keep taking remote depositions, or I'm not ready yet. I've had cases where lawyers said, I need the staff of the company to help me review these documents, and some of them are furloughed and it's taking longer that way. But I'm trying to keep the cases moving along. Joel or Deborah?
Yeah, I've had a couple of cases in which one party says, I'm not going to take the deposition of the key witness on the other side by Zoom. That just doesn't work for me. I want to be there in the room. I want to watch his face and his attorney's face. And if anybody else is there, I want to watch their face. So we can't arbitrate until I get in-person depositions. I don't think there's any basis for that, but I've had a lot of people say that we have to postpone this till whenever the pandemic is going to end. And whoever can tell me when the pandemic is going to end and we're all going to be in each other's offices without masks, they get the prize. But that's been a hard one for me. And I think that you sometimes just have to issue a hard ruling that says, no, I know you want to take the deposition in person, but we can't do that. And so either you take it by Zoom or other method that's virtual, or you just go to trial without that deposition, which is a pretty big risk. So that's been one thing. Once we get into the arbitration, I have actually found Zoom in many ways preferable. In all of my arbitrations that took place in person at a JAMS office, we always had trouble with witnesses. They were supposed to show up at 2 o'clock, but they forgot, or they got into traffic, and now it's 4 o'clock and we've wasted 2 hours waiting for them. But in a Zoom arbitration, when everybody is at home or in their office and immediately available, even if somebody forgot, oh, I'm supposed to testify at 2 o'clock, you just call them up, jump on Zoom, you're up. And I think it's really been helpful to keep things moving along rather than in the case of in-person where you just have to somehow sit there, twiddle your thumbs while some witness fights traffic on the 405.
Yeah, I think that Zoom arbitrations work really well. And at the beginning of the pandemic, there was a lot of hesitation by the parties to do it. They didn't want to do it. They didn't like the idea of not being in the same room as everybody. But I went ahead and ordered them pretty much. And they've worked just fine. The only thing that I think really is legit in terms of delay is sometimes the defendant or the respondent in an arbitration is representing a party that's basically closed down, and they can't get the documents, and they can't get the witnesses, and they can't get even to the office, to get the stuff. And so that has caused some delay, and that's legit. But beyond that, I think there's not much that's legit. If people don't like electronic depots, it's kind of too bad. I think we need to go forward. We can't just let things sit.
Now that segues into the very insightful question from one of the attendees who noticed that I did not finish answering the issue of what happens and what am I doing with regard to where claimant's counsel wants to be in person at the respondent's deposition if respondent's counsel is going to be present. Well, first of all, I told respondent's counsel to talk to their client and see, does that executive really need respondent's counsel to be present? Because I said, after all, your witness is not, he's a big boy. I said that he's not a scared, frightened claimant who's never been in litigation before, who doesn't know, who needs a lawyer to hold his hand. So let's see if you really need to be in person. And number two, if you really do need to be in person, is there a way we can set up 2 cameras? One that is your typical video deposition camera that's videographing, however you say that, the witness and only the witness. And then the other one that is showing the entire room so you can see that the lawyer is sitting 6 feet apart at the other end of a conference table, and that they are not communicating. You can watch and see, just as you would in person, that they're not communicating. Of course, you can never quite tell what somebody's doing down below the Zoom screen. Do they have their iPhone there, and are they texting away questions and answers? So I said, I didn't decide it yet, but I said, let's see what respondent can propose. Either the lawyer won't be there in person, or the lawyer will be there in person, but it will be set up with cameras so that the claimant's counsel doesn't feel disadvantaged, or claimant's counsel can go and respondents are going to have to make sure that the area, meets standards, CDC standards for having multiple people in the same room, which is it better be a large room and people wearing masks. Now, do you require the deponent to wear a mask or not? Arbitrators are divided on that. And I was talking to a number yesterday. I prefer that they don't wear a mask so that you can see them, but put a plexiglass screen in front of them. I mean, it's hard although I can see if someone is testifying, I can see if they raise their shoulders or twitch or their eyes go around, even if they've got a mask on, and that may indicate that there's some anxiety about what they're saying. One person said that they did it and they required the deponent to have a microphone, even though they had a mask, and they had a mask on, but the microphone made it so everybody could hear. So any experience, Joel and Deborah, on, what would you do? And the way I should take a poll of all the people here and say, what do you think I should do in that case? Except Barbara, if the parties are here, they'll be lobbying.
Barbara, we have reached the 9 o'clock hour, and we have promised to let all our good people actually get to work and work on other projects. And we want to thank Barbara very much for very insightful, useful information. And my best advice to everybody here is keep those materials that you received handy, because this issue, especially the issue of third-party depositions and discovery in general, is going to keep coming up until we hear further word from the courts of appeal. So thank you, Barbara. Thank you, my fellow moderator, Debbie, and thank you, Ramit, again, for organizing these wonderful programs.
Hi, everyone.
Thank you, everyone.
Bye-bye.